Thanks for being here. Welcome to day 2 of the symposium. I am Dan Rowland with Denver Excise and Licenses and the Office of Marijuana Policy, Director of Public Affairs, which means I do all of our sort of communications with media, the public, and a lot of communications with other governments and folks that are looking to Denver to keep this conversation going. So it's a privilege to host this event and have you all here. You know, we get so much out of this event as a city, and just from the conversations I heard yesterday, it seems like the attendees are getting a lot out of this event as well, and I just can't thank you enough for making the trip here and spending a couple days with us. I know it's a lot of information, and we're going to get going on day 2. I yesterday talked to people from at least 9 different states and 3 different Canadian provinces. I'm sure there's more than that represented here today, but I just wanted to give you guys an idea of where people are coming from: Nevada, Colorado, California, Michigan, Washington, Alaska, Hawaii, Florida, Oregon, Alberta, Ontario, British Columbia, and I'm sure several more that I've missed. Thank you again for being here. I won't turn this into an Oscar speech, I promise, but I do have to say a couple thank yous. Kathy Nixon and Creative Special Events, we could not do this event without her really great hard work. Jose, Kevin, the guys in the back running the AV, thank you guys so much for keeping us on track here. And of course to Cassie and the Embassy Suites for having us this week. And my team in the Office of Marijuana Policy, my friends and coworkers, Natia, Molly, Ashley, Marley, everyone who's put so much effort into making this content over these 2 days really valuable. And first and foremost to Bia Campbell. I think many of you talked to Bia either about hotel rooms or tickets or registrations or some of the details with the event. She has been an absolute rock star over these last few months helping me put this together. So yeah, thank you to Bia for that. And without further ado, we'll get into our second National Roundtable with Mark Bolton from the Governor's Office. Thanks.
Good morning, everyone. My name is Mark Bolton. I serve as Senior Deputy Legal Counsel to Governor John Hickenlooper of Colorado, and also as the Governor's Director of Marijuana Policy. I just want to echo Dan's appreciation and thanks, and of course thank Dan and Ashley and Molly and everyone, all the hardworking people at the City of Denver who put on this this tremendous event, and the event sponsors as well. It's a pleasure to be here with you guys. So I'll be your MC, for lack of a better term, for this morning session, and I'm joined on stage with a great panel of individuals who are all leaders in their jurisdictions, marijuana policy and regulatory efforts. We're going to do it a little bit differently this morning than we did yesterday. So we'll each provide a brief overview of our jurisdiction's regulatory systems and a few issues that we're dealing with at this time, and then we'll save plenty of time at the end for questions. And so I'm up first. I'm going to spend most of my time talking about a few key issues that are of real significance to the state of Colorado at this time, and then finish up by discussing ongoing conversations that we've been having between representatives of state governments and the federal government in ways that we think the states and the federal government can work together on issues of legalization. So. Colorado, of course, we passed adult use legalization in 2012. At that time, my boss, Governor Hickenlooper, stood opposed to the initiative, but it passed, obviously, with a strong majority of approximately 55%. Let me just make sure I can get these slides going. Excuse me. Let's change it. Perfect. So with the passage of the amendment, obviously our task became working to implement the will of our citizens by implementing a comprehensive regulatory and enforcement system that prioritizes public health and public safety. So our system now consists of approximately 12 state agencies that have at least some role in our system of regulation and enforcement. You can see on this slide the 3 primary agencies that probably play the most significant role in our system: the Department of Revenue and the Marijuana Enforcement Division, the Department of Public Health, and our Department of Public Safety, and the sort of primary roles that they play. My role in the system is primarily one of a coordinator. I work with all 12 agencies and oversee the various policy issues that we're dealing with. And then there's quite a bit of sort of interagency interaction on a handful of issues. And so when those occasions arise, I'm working to make sure that our work is synchronized across agencies. And Colorado's had someone in that capacity since retail sales began in January of 2014, and it really has been a critical component of the successes that we've had. So at this point, Colorado certainly has, after these years, one of the most mature marijuana regulatory systems in the country. And in a lot of ways, we've become a model for other states and their jurisdictions that are experiencing legalization or considering going through this. But with that, and while we believe we've built a strong and effective system, we're constantly evaluating and seeking to strengthen our approach to regulation and enforcement. And as I hope I can demonstrate today, we maintain a strong commitment to addressing any unintended consequences or abuses that materialize. And so with that, let me get into a few of the major issues that we're dealing with in Colorado right now. So the first is diversion of marijuana outside of Colorado. Preventing diversion both to the black market in Colorado and outside of Colorado remains one of our top priorities. So within the regulated market of licensed businesses, we've implemented a handful of strong inventory control and enforcement mechanisms to prevent diversion from marijuana businesses. And those include a state-of-the-art seed-to-sale tracking system, which I know you guys heard quite a bit about yesterday. The primary components of that, or the primary strengths are, it enables real-time remote monitoring of business-to-business and retail transactions. And it also captures perpetual inventory quantities for each marijuana quantities for each licensed business. We also impose caps on cultivation facilities, production capacity, which helps to prevent overproduction that can lead to diversion. We require 24-hour video surveillance in all marijuana businesses, and we maintain criminal penalties for distribution and possession of more than 1 ounce of marijuana. And I think we have a high level of confidence that generally speaking, the marijuana businesses that we have operating here in Colorado do in fact honor this closed loop system that we've built. But like I said, we're constantly looking for ways to improve our system, to build on what we have. And so one example that's come up lately is based on input we've received from law enforcement, from regulators, and from other folks in the industry. We know that people are working to, people outside the system, I should say, are working to accumulate large quantities of marijuana basically through successive purchases at retail stores, right? They'll go into a store, buy their allowable ounce, take it out to their car, put it in the trunk, come back in and buy another ounce. It's a practice that is commonly referred to here in Colorado as looping. So what we're in the process of doing now is finalizing some new regulations that are aimed at addressing those issues. And specifically what we're going to do is prohibit try and put the burden to some extent on the businesses to prevent this looping activity by prohibiting them from knowingly selling more than 1 ounce to an individual during a business day. There are some restrictions in our Constitution that prohibit us from implementing a tracking system similar to what exists for Sudafed, but within the bounds of what we can do in the Constitution, we want to try and close this system as much as we can. And one thing we think we can do is put the burden to some extent on these businesses by requiring or prohibiting them from selling more than 1 ounce to somebody in a business day. You guys heard a lot yesterday about home grows. There was quite a bit of discussion while I was here yesterday about home grows, and rightfully so. Colorado has had significant challenges with home grows. In fact, intelligence that we receive from federal, state, and local law enforcement indicates that the primary source of diversion, both to the black market here in Colorado and even more so out-of-state diversion, is not so much the licensed businesses that we have here, but abusive home grow activities that most often take place under the guise of lawful medical marijuana production. And the fundamental problem here in Colorado is our personal cultivation allowances, which are in our Constitution, not so much in statute or something we can deal with easily in statutory change, position the state as an attractive destination for criminal organizations looking to come in and grow large quantities of marijuana for distribution on the black market. So of the 29 states now that have legalized marijuana for medical or recreational purpose or adult use purposes, or both, a lot of them prohibit personal cultivation altogether, and others limit personal cultivation allowances to somewhere between 4 and 16 plants. Colorado, on the other hand, on the medical side, allows patients to grow up to 99 plants. And until this summer, we did not impose any effective cap on adult use grows because we didn't have any prohibition on marijuana growing cooperatives. And so what we're seeing is an influx of criminal organizations that were entering the state, and as I said, growing large quantities of marijuana under the guise of lawful medical marijuana production. And in most cases, these were not 1 or 2 people growing 20 plants in their home to sell to a handful of people around town, right? These are much larger, more sophisticated criminal organizations that were often operating across several homes and in a lot of situations across different jurisdictions. So we've tried to implement a handful of strategies to address these issues. The first is just good old-fashioned police work, right? Our local law enforcement, state law enforcement, often in conjunction with the DEA, execute enforcement actions to dismantle these criminal organizations. In fact, we had the largest bust since legalization occurred just this summer when 74 people in a marijuana distribution ring were indicted. The second is earlier this year, we went to the legislature and enacted a sort of a host of laws aimed at addressing this issue. And you heard a lot of discussion yesterday about local jurisdictions, cities and counties who have imposed home grow limits, right, caps on the number of plants that can be grown in a home. The challenge that we had there is that those are typically enforced as zoning violations, and so the most serious consequence for these violators is ultimately a $1,000 fine, and that can only be imposed after an extensive process at the municipal or county level or whatever the case may be. And so for these more sophisticated and larger criminal organizations, that is simply the cost of doing business and just not a sufficient deterrent. And so we came in and passed a host of 3 laws. The first is we imposed criminal penalties at the state level for growing more than 12 plants in a home. And that's regardless of whether the plants are being grown for medical purposes, recreational purposes, and regardless of how many people are living in the home. So a hard cap of 12 plants in the home. We provided $6 million through a reimbursement program for local law enforcement to use to support their gray and black market enforcement efforts. And we banned marijuana growing cooperatives, which I said were expanding home grow problems as we saw. So we think these are a helpful first step. I think, unfortunately, these criminal organizations have a foothold here in Colorado to some extent, and so there's more work that we feel like we need to do in order to address these issues, and we'll pursue further resources as we move forward. Next issue, keeping marijuana in the hands of kids obviously is an important priority for the state. The good news is multiple data sources indicate that youth use in marijuana has basically, in Colorado, marijuana use in Colorado has remained stable following legalization. So the survey that the state issues, which is called the Healthy Kids Colorado Survey, and it's really one of the more robust youth behavior surveys in the country, and with approximately 15,000 participants, has found no statistically significant increase in youth use since legalization, and in fact shows Colorado's youth use rates in line with the national average. And then the National Survey on Drug Use and Health, which is administered by the federal government, has also shown no statistically significant change in marijuana use among Colorado youth since 2007 and 2008. And in fact, the most recent data set, so between 2013-14 and 2015-16, which is the period in which adult use stores opened here in Colorado, the NISDA survey showed a 12% decline and decrease in youth use. So while these statistics are encouraging for us, obviously our ultimate goal is not just to stabilize youth use in Colorado, but to in fact diminish it. And so we've tried to implement a few strategies to achieve those outcomes. So first, we've appropriated $22 $22 million thus far in marijuana tax revenue to public education campaigns that are aimed at educating youth about the risks of marijuana use. And the primary components of the campaign are called Protect What's Next. And so what that does is it encourages youth to consider how marijuana use may prevent them from achieving the goals that they're currently pursuing in their lives. So high school kids trying to make a sports team or trying to get into college, or I think we even have some education about the effect that marijuana use can have on your ability to find a date. And so I assume that resonates well with some of these kids. And the other piece is what we call the Trusted Adult campaign. So educating parents, teachers, and other trusted adults in kids' lives to talk to youth about the risks of marijuana use. And then we've also used a handful of other more school-based programs that are aimed at addressing issues associated with youth drug use. And those include dropout prevention programs, after-school programs, youth mentoring, bully prevention, and then just this year, we received $12 million in marijuana tax revenue, for additional behavioral health professionals in schools. And so those are typically nurses, counselors, and social workers that provide substance abuse intervention and education and treatment programs. So this is an ongoing issue for us, and is something we'll continue to focus on. And as I said, our ultimate objective here is not just to maintain, flatlines youth use, but to in fact decrease youth use here in Colorado. So next issue is roadway safety. Obviously another priority of the states. So immediately following legalization in Colorado, at least adult use legalization, the state enacted new laws giving state and local law enforcement additional tools to prosecute individuals driving under the influence of marijuana. And so the primary example would be we now have a 5 nanogram of THC per milliliter of whole blood limit, which law enforcement can then infer that a driver is operating a car under the influence of marijuana. We've also significantly increased training of law enforcement to detect drug-impaired driving. So we've increased by 68% the number of drug recognition experts that we have in the state. So there are now 227 drug recognition experts operating in Colorado, and we've trained over 1,100 peace officers in advanced roadside impaired driving enforcement. We've also appropriated $2.3 million to the Department of Transportation for public education campaigns, and those are typically geared at conveying the criminal penalties and dangers obviously associated with driving under the influence of marijuana. And because of the challenges with detecting roadside detection of impaired driving, we're exploring improved measures to detect marijuana impaired driving. So our state patrol is now in the second year of a pilot program to use new roadside detection methods, and the primary focus there is an oral fluid testing unit. Next topic. So following legalization here, we did see an increase in both marijuana-related emergency department visits and marijuana-related exposures. And marijuana-related exposures are measured in calls to the Rocky Mountain Poison Control Center. And so our state health officials attributed those initial increases, to a few factors. First is a greater willingness among health professionals to inquire about marijuana use, and a greater willingness among individuals to in fact report marijuana use following legalization. Also unsafe consumption of edible marijuana products and accidental ingestion, primarily again of edible products. And so by identifying these factors, we've been able to respond in a targeted manner to educate and protect the public on these issues, and we're starting to see these trends reversing, which I can get into in a minute. So first, what we've done is, again, we've used marijuana tax cash funds for public education campaigns, and those primarily focus on the health risks of marijuana, educating consumers on the parameters of safe marijuana use and safe marijuana storage, and then advising consumers to seek medical help immediately if they experience a bad reaction to marijuana. We've also dramatically changed our regulations of edible products to prevent unsafe consumption and accidental ingestion. And so first, to protect against unsafe consumption, there's a few primary components. First, we've limited the THC content of edible marijuana products. So now a serving of an edible product can only be 10 milligrams, and no edible product can have more than 10 servings or 100 milligrams of THC. We require that both on-package labeling that conveys the THC content of each product, and then we've required that in those multi-serving edible products that each serving be clearly identifiable and easily separable. So if you think about a Hershey's bar, right, it's easy to know when you're moving from one piece to the next or from one serving to the next, so that it's intuitive to consumers when they're moving from 10 milligrams to 20 to 30 up to 100. To prevent accidental ingestions, we have now required that both the packet, an edible product's package, and then the edible itself must bear a universal symbol, which is, I think, if I remember right, it's basically I can't remember if it's a triangle or diamond. I think it's a triangle with an exclamation point and the letters, capital letters THC in it, and that universal symbol has to be on both the edible product itself and on the package, which we think will go a long way towards addressing accidental ingestions. We've also focused heavily on creating regulations aimed at protecting children. So the primary components of that effort include a prohibition on manufacturers infusing pre-manufactured products with THC. So you can't buy gummy bears off the shelf now at Costco and infuse them with THC. We've prohibited edible products now in the form of fruits, animals, and humans. So again, trying to address issues with Swedish fish and gummy bears and Sour Patch Kids infused with THC. And then now all edible marijuana products have to be sold in a child-proof and resealable package. And so as I mentioned, our most recent data shows the emergency department visits and the exposures decreasing. The most recent data we have on the emergency department visits comes from 2015 and shows a 27% decrease in emergency department visits. And the most recent data we have on the exposures shows a 12% decrease in 2016. So certainly, 1 year doesn't make a trend, but fortunately, after these regulations went into place, we did see the increased trend that we were seeing reverse. So last thing I'll talk about before I turn it over to the other folks on the panel is the ongoing conversations that we've been having with the federal government. And of course, this issue has received a whole lot more attention now after we changed federal administrations here in the United States. So I'd just like to share Colorado's perspective on this, and then happy to take any questions about it. So as I said at the outset, I think the state has built we feel confident that the state has built a comprehensive regulatory system that prioritizes protecting public safety and public health. And while we think our system has proven to be effective, we're constantly in a state of evaluation. We're committed to continuing to improve on what we've seen and to addressing unintended consequences as they materialize. And I hope I've provided a few good examples of that here today in the brief time that I've got. And ultimately, we believe that the objectives underlying our regulatory system are consistent with the federal government's ultimate objective, which is controlling the production and distribution of marijuana in the interest of protecting public safety and public health. And so we think the best way, from our perspective, the most effective way to achieve these shared interests is a collaborative relationship between the states and the federal government, where we can share information in a productive way, focus on ways that we can strengthen our regulatory and enforcement system to protect public safety and public health, and then also continue to collaborate. As I mentioned, a lot of the law enforcement efforts that we've undertaken to enforce on these home grow issues that we've had have been a collaborative effort between local law enforcement, our Department of Public Safety on occasion, and the DEA. And so continuing that collaborative enforcement between states and the federal government for folks who are violating state and federal law by producing marijuana for distribution on the black market, we think is an important component of that. And so we've engaged in collaborative dialogue with the federal government and representatives both of the Justice Department and the White House dating back to April. I think we stand committed to continuing those conversations and working together. And I think we have a high level of confidence that if in fact we can engage in that collaborative dialogue and continuing working together, that in fact we can achieve a regulatory system that advances our shared interests. So I know with that we're fairly short on time and want to preserve time for more questions. So I'm going to turn it over to Dion next. And Dion Contine is the Executive Director of the Nevada Department of Taxation. She was appointed by Governor Sandoval in November of 2014. And in her current capacity, Dion's responsible for implementing adult use marijuana program in Nevada, including licensing and regulating the state's marijuana businesses. Prior to her appointment to the Department of Taxation, Dion served as the Deputy Director at the Department from 2012 and served as legal counsel to the Department as a Senior Deputy Attorney General from 2008 to 2012. So if you would please join me in welcoming Dion.
Good morning. I am Dion Contine. I'm from the state of Nevada, and I've given a few of these talks in our state, and I say that I used to be the tax collector. That was my job, and now I just do marijuana every day. I didn't apply for this job. This job essentially found me in that in the initiative that was enacted in our state in November of last year. It put the responsibility for licensing and regulating the marijuana industry into the Department of Taxation. I'm going to talk about this, basically our 6 months, or our last 6 or 7 months, and kind of our timeline and the actions that we took and how we implemented our program. So again, in November, the ballot initiative passed, and it made legal possession of 1 ounce and 1/8 of an ounce of concentrate, and that legality began on January 1st, 2017. The department, again, was tasked with licensing and regulating the industry, and we had up until January 1st, 2018 to do the regulations. Under the initiative, the department is also responsible for collecting a 15% wholesale tax. So that all happened in November. In January, Governor Sandoval issued his governor's recommended budget and the State of the State address, which included about $100 million for the biennium for marijuana revenue. And he also proposed at that time an additional 10% tax at retail. So that's when it was pretty obvious that we would be starting our program prior to that January 1st, 2018 deadline, because the governor and then subsequently the legislature included those funds in the budget. So from January, the State of the State happens. February, our legislature comes to town. They meet from February to June. They enact the 10% tax. And they also make some changes to our medical marijuana program, which had begun in 2015. And they transferred the administration of that program into the Department of Taxation so that the programs were together and we would be administering and licensing and regulating both programs. Also during that time, we did a governor's task force process similar to what was done in Colorado when they went for legalization, not as big, but we had 19 members from the community representing various sectors: public health, law enforcement, social services, local governments, regulators, and legislators. There were 8 working groups in that, and the working groups focused on the topics, the regulatory topics, essentially from the initiative, and looked at, basically we took the medical as a foundation and just talked about over those various categories of regulation, like what had worked and what had not worked and how we could make it better, what needed to be changed. The working group met again from March to May, and a report was issued to the governor at the end of that process. We had about 60 public meetings, and where people could come and make public comments, and working groups were working together with task force members to flesh out these issues. Also at that same time, so I'll talk a little bit about the regulatory process that we went through. In Nevada, we have different periods of the year where we do what's called either temporary regulations or permanent regulations. So during the legislative session, agencies don't do permanent regulations because there's a legislative component to it. So when the legislative staff and the legislature's in town, they don't have the time to do that. So we did a temporary regulations, which are a shorter process. There's not as much review. There's a requirement for one workshop and one adoption hearing. So it's not a complete full process that we would normally do for permanent regulations. So in the regulations, we basically used the medical as a guideline, but there were a couple of differences, and we addressed those in these regulations. We provided for a May 31st application deadline, and under the initiative, only medical marijuana establishments can apply for adult use licenses for the first 18 months from when the department begins issuing licenses. And then there is one additional license type, and this is kind of the important point in this whole presentation, because this is how most of the problems and most of the issues that we faced have evolved, is based on the provision that requires a marijuana distribution license. We don't have a distribution license category under the medical program. And the other issue with it is that marijuana distribution licenses can only be issued for the first 18 months again to entities that also hold an alcohol distribution license. So that was one of the differences that we had to deal with in regulation, and we attempted to deal with that difference by allowing establishments that had been transporting marijuana under the medical program. And mostly that was self-distribution. So if you were a licensed cultivator, you may also have a licensed retail store. There was no requirement to have a license to transport your product. And so to allow in the application process for the licensed medical marijuana establishments who were getting a adult use license to also apply for a distributor's license. So in June, there was a small group of one or two, basically, alcohol distributors. And I'm just going to talk a second about the barriers for the alcohol industry to come into marijuana that we kind of saw at the outset. Sorry, let me just back up one second. The marijuana distribution provision also included an out for the department to make a determination that there were not enough of those licensed distributors to serve the market. So that was the out in the initiative, was that we could make that determination if not enough people applied. The barriers to entering this market for alcohol distributors were basically, the timeline was one. It gave them this exclusivity, or this perceived exclusivity for 18 months, which, as some of you probably know, as you've regulated this industry, it's hard to kind of get up and running, and there's a lot of work that goes in, even for the businesses, to get to the point where they can get a license. Not having any knowledge of the industry, the alcohol is not perishable. There's not the timing issues with deliveries. So that the kind of the lack of the knowledge of the distribution process, and also the federal alcohol issue. So the federal government licenses alcohol wholesalers in our states, as well as our state licensing. So those were some of the issues that they were facing. So not surprisingly, not too many of them were interested, especially ones that are the bigger businesses that had a lot of business relating to wholesale distribution. Nevertheless, in June, the court, a couple of the smaller distributors sued the department and basically said that we were attempting to keep them out of the market. And the court at that time issued an order prohibiting the department from licensing a marijuana distributor unless it was an alcohol distributor, until we made some additional regulations that set the rules for what we would use in determining this insufficiency to serve the market. Notwithstanding that little barrier, in July 1st on 2017, legal sales began in Nevada. We had at that time licensed 50 licensed stores, and again, these were all licensed stores that had medical marijuana establishments, licenses, dispensary licenses, and at that time we had not issued a single distributor license. So prior to that time, the retail stores began stockpiling based on the uncertainty around the licensing. So they transported under the medical program inventory to their stores, so that without distributors, they would have inventory on hand because of that uncertainty. So in July 13th, we actually had an emergency regulation hearing, and we adopted a regulation where we set out the framework to determine whether the liquor wholesalers were sufficient to serve the market. We looked at the ability of the liquor wholesalers to serve the market, and we reviewed their capacity, their competency, and whether the liquor wholesalers were committed to serving the market by investing human and other resources. So this was the framework that we set in place for that in the emergency regulation. They challenged, again, the emergency regulation to the court, and said that it wasn't valid because there was no emergency. The court declined to intervene at that point. They didn't issue another injunction stopping us. Also, on the same day that we did the emergency regulation, we licensed the first alcohol distributor to distribute marijuana, and that was a company that had an alcohol license and also had a partnership with a company that had been distributing marijuana under the medical marijuana program. So starting in July, we began the permanent workshop process. We had 8 different workshops. We have about 200 pages of regulations, and those regulations incorporate many of the recommendations from the governor's task force. And they are on review with the Legislative Council right now, and that's the process that goes for the permanent regulations. Is there's that second level of review, and we're hoping to have those adopted by sometime after the first of the year. So in August, we did hold this sufficiency determination hearing. We used the framework from the emergency regulation and presented our determination in the meeting. We also took public comments from interested parties. When we had that hearing, only 2 people spoke in favor of keeping the market closed only to alcohol distributors. And at the time that we had the sufficiency determination, there were 7 licensed distributors and only 2 entities that were actually operating, like fully operational, and transporting enough product to serve even just more than maybe 1 entity. And at the meeting that we had to determine the sufficiency there, the testimony was around kind of the bottleneck that the stores had when they were attempting to resupply their products. Products would be ready at cultivation and would sit there and wait several days before somebody could come and pick it up. There was a fear, or kind of that the less products that we have, the less ability to get product from cultivation to the retail stores. It means that there's less to buy, and so then there's the concerns about the retail, about the revenue and the projections that went into bringing the funds in for the state. And so those were some of the issues. In November, the Nevada Supreme Court heard oral arguments on the liquor distributor issue of their challenge to the emergency regulation, that it wasn't an emergency regulation. and they haven't issued a ruling yet. So they did say that we cannot issue any additional distribution licenses. But to date, we have issued about 24 distribution licenses to entities that are not alcohol distributors, and we've issued about 8 to alcohol distributors. And then also in September, we got our first revenue numbers came in, and we collected in the 2 tax types, the 15% wholesale and the 10% retail, about $3.68 million in revenue. And for August, we just finalized the numbers for August, and we're at about $4.8 million total for the month of August. So notwithstanding the hitches along the way, the issues that have come up, we've implemented the program and we've had some success. This is a little bit about our enforcement model. Again, we have the combination of the medical and recreational. We have inspectors, auditors, compliance audit investigators, and they do the more kind of egregious, the real issues that we have that come up. Since we've started the program, we've already assessed civil penalties. We've suspended a lab license. And we've actually helped in shutting down an illegal unlicensed storefront. So again, I'll just quickly go through this. The key issue really in this whole program has been the distribution issue. I think we're at a good point, but I'm hopeful, and I hope for a day that we have just a regular distribution model and a regular distribution market, and I think that will be the key to kind of really being successful in this program, is having the ability for businesses to have the service as they need it. And then just a little bit about the success. We did have a 6-month implementation from passage of the initiative to when the department began accepting licenses. It was 6 months. To date, we've licensed 91 cultivators. We licensed 5 retail stores yesterday, so there's, and that was based on a local government's zoning. They did the zoning for adult use. We've licensed 58 retail stores, 64 production facilities, 9 labs, and 32 distributions, and I would say, we all did a lot of hard work, but really much of our success was having that solid framework under the medical program, having already a strict and a tight regulatory process in place, building on what other states were doing, and building on what other states were doing, and also support of the industry, willingness to accept the rules and not fight too much on most anything that we wanted them to do. So I think those 3 components were led to the success, and the ease, I guess. It wasn't easy, but it made the process a lot easier to implement. And that's all I think I have.
Thank you, Dion. And our next presenter is Erica McConnell. Erica was appointed Director of the Alcohol and Marijuana Control Office for the state of Alaska by Governor Bill Walker in March of 2017. So in her current capacity, Erica oversees the licensing and regulation of commercial marijuana establishments in Alaska. Prior to her current position, Erica worked in land use planning in the municipality of Anchorage for 14 years. So with that, please welcome Erica McConnell. So you can just get you set aside there.
Good morning. It's a pleasure to be here and speaking to you all about Alaska's marijuana regulations. A little bit about our regulatory organization. Our state has a marijuana control board, which is established to control the cultivation, manufacture, and sale of marijuana in our state. Thank you.
Thank you.
There, thanks. Our board it's a 5-member board, and they are all volunteers. They're appointed by the governor and confirmed by the legislature. And on our board, we have 2 seats for industry members, a public safety seat, a public health seat, and a general public seat that has to be occupied by someone from a rural area in our state. The staff of this board is the Alcohol and Marijuana Control Office, and we are housed within the Department of Commerce, Community, and Economic Development. And our staff includes 6 licensing positions, 8 enforcement positions, of which 5 are located in Anchorage, 2 in Fairbanks, and 1 in Juneau, 1 education specialist, and 4 administrative positions. And our office also has the alcohol program, where we license approximately 2,000 alcohol licensees. And the staff that I mentioned does all the work for both alcohol and marijuana. So we don't have dedicated staff for just one of the programs. We all do both. Our ballot initiative passed in November of 2014, and one of the things that has been very different about Alaska from the other states that we hear about is that we didn't have an established medical program. We do have a medical registry and medical cards, but there was no system of dispensaries or grows, so we weren't able to build on that established situation that Dion talked about in Nevada, and I know has existed in many other states. So that was a challenge for us. So after the initiative passed in 2014, the board had essentially 1 year to develop regulations, and there were a number of workshops and hearings and a great deal of public input and comment. And those regulations were finalized in early 2016. Our first licenses, which were for cultivation and testing facilities, were issued in June of 2016, and the first retail store in Alaska opened in October of 2016, about a year ago. So we have 9 provisions, 9 sections in our regulations, and for those of you who heard yesterday's presentation by Kyle from Colorado MED, some of this will sound familiar to you because our regulations were heavily modeled after Colorado's, and we thank Colorado for all of their generous help to us. So our sections about licensing and fees and general requirements and provisions apply to all of our licensees. And these include things like separation from certain protected uses. Our licensees have to be Alaska residents, and they are not allowed to have certain disqualifying criminal convictions. Our local governments have a certain period. They have 60 days from the time that an application is determined to be complete to protest the issuance of that particular license. And their protest must be upheld by the board unless the board finds it to be arbitrary, capricious, and unreasonable. Licensees have to be renewed yearly. All licensees, employees, and agents have to have a handler permit, and handler permits are issued by my office, but to get a handler permit, they have to complete a course, a handler permit course, and the board licenses the course providers, but the courses are given by private providers. The licenses are issued for specific premises, so you have to actually have a location established and control of that location before you can apply for a license. And certain areas within those premises are restricted access, and that varies by license type because, of course, a retail store is going to have, areas where the general public can go, but a cultivation facility really has no area for the general public. So a cultivation facility is pretty much all restricted access, whereas a retail store is only going to have partially restricted access areas. There's the general security requirements, camera coverage, lighting, commercial grade locks, alarm systems, that sort of thing. And we also have the seed to sale inventory tracking system and regulations regarding, secure transportation. Transportation is allowed to be done by the licensee, employee, or agent. So we don't have a situation that's similar to Nevada's, but we do have a requirement for a manifest where they have to be very specific about how and when and by what method the transportation is occurring. One major difference from Colorado is that we do not control or monitor inventory, supply, and demand. We didn't do any sort of needs assessment in Alaska about what we thought the market would bear. We don't control the number of licensees, and we don't control the amount of product that is produced. So we have 4 types of licenses: retail licenses, cultivation facilities, product manufacturing, and testing. There's a couple of subsets. Our cultivation licenses, you can either get a limited cultivation license, which authorizes you to grow 500 square feet, so your canopy would be 500 square feet, or an unlimited license, which is unlimited. And our manufacturing license can either be a concentrate-only license or a general manufacturing license. And the benefit of those limited types of cultivation and manufacturing licensees are just that they're a little bit cheaper. Our retail stores, they do require a food permit from the Department of Environmental Conservation. They have packaging and labeling requirements. There are limits on the quantity that you can purchase, but similar to Colorado, it's a per transaction limitation. So and we are not also allowed to collect individuals' data to track who's purchasing, and so we do have the potential for the looping issue that was mentioned earlier, although we haven't yet seen that to be a significant problem. You know, in Alaska, it's a lot harder to get to the next state, so that out-of-state diversion hasn't so far shown to be as problematic for us. There are advertising restrictions. Currently, these are only placed on retail stores, but we are seeing issues with other types of licensees also doing advertising, so we are working on a change in our regulations that would apply advertising restrictions to all the license types, not just the retail stores. And to get a little bit more specific about the challenges with the different types of advertising, because your print advertising is different from your internet advertising, is different from your radio advertising. There are consumer notices that are required. One of the issues actually came up particularly in Juneau, which gets a lot of cruise ship traffic, and they wanted it to be clear that tourists who may choose to purchase while they're in Juneau are not authorized to take their product back onto the cruise ships, things like that. And then, as I talked about yesterday in the social consumption panel, that there is the potential for an on-site consumption endorsement, and the board is currently working on regulations about that. Our cultivation facilities, this is where our tax is collected. Our tax was set by the initiative to be a exact $50 an ounce tax instead of a percentage. The Department of Revenue actually did a regulations project where they changed it a little bit, so it's $50 an ounce for bud or flower, but only $15 an ounce for trim, because trim is less valuable. Product manufacturing facilities, again, food permits required. We do not allow infused fats or oils to be sold directly to consumers. If those are produced, they can only be sold to another product manufacturer to create edibles. Closed loop system for solvent or gas-based extraction. Our serving limit is where we learned from Colorado. Colorado had set a 10 milligram per serving limit and had told us that they wished they had started a little bit smaller. So we actually established a 5 milligram per serving limit with 10 servings per package for a 50 milligram total package limit. And then our testing facilities, testing requirements, some of the particular things that I would point out, which I'll reference a little bit later, is that when you harvest a batch, when you have a harvest, which is all of the plants of one particular strain that are harvested at the same time, we only require one sample from that entire harvest batch to be tested, no matter how big it is. And when you create a production batch of edibles, we only require one edible to be tested, again, not related to the size of that production batch. And at this time, we are not doing any pesticide testing. We don't have a lab in Alaska that has the capabilities to do pesticide testing. We only have 2 licensed labs. We do not have, we don't have a state lab that can also do pesticide testing. So that is an issue that we are concerned about. We do have a local option provision in our regulations, which allows local governments to decide to opt out of commercial marijuana. They can do this either through voting or by ordinance. They can prohibit the sale or importation of marijuana, or they can limit the license types that are allowed in that local community. They are not allowed to prohibit personal grows. That is a right that is given under the law. And so while they can't prohibit the use of marijuana, they can prohibit the commercial sale. Under our enforcement regulations, we do, of course, require an inspection before issuing a license. We have advisory notices, which are a type of communication between the office or the board and the licensees. And these are used for general guidance, correcting misinterpretations of regulations that we may hear about, or also to communicate where we have suspected that a violation has occurred, but we are not actually able to prove it. When we are sure that there has been a violation, we issue a notice of violation, and the board sees all of the notices of violation and gets to determine whether they want to take additional action regarding that particular violation. In addition, I have the authority to create an accusation to initiate a proceeding to suspend or revoke the license. This is something that I take to the board, and then the board makes a decision on how to proceed. I have the authority to do a summary suspension, which means an immediate, shutdown right now to protect public health, safety, and welfare. I've exercised this authority once, but it has to be followed within 5 days by a hearing before the board, so that the board gets to make a determine, was it justified, should it continue, what are the ramifications of that. We have seizure provisions, which have to be followed by a board hearing within 10 days. We have a series of civil fines, and our licensees, of course, have appeal rights. They can appeal an adverse decision by the board to a formal hearing by an administrative law judge, and if they are not happy with the results of that, they can then appeal to Superior Court. So, key issues and challenges in Alaska. I think the biggest issue that we've had has been sufficient staffing resources. As I mentioned, we have 21 positions to deal with our entire marijuana licensing program, as well as our entire alcohol licensing program, and it has been just really challenging to get everything done that needs to be done. I know that we have been, that there's been unhappiness in the industry at the way the program has rolled out, and the fact that licensing has been slower than they wished. But that's how it's been with the resources that we've been given. Setting precedent has been a concern of mine. We're in a situation where a licensee may violate a rule, and it's the first time you've seen that violation, and the way you decide to handle that violation does create a precedent. And while we do have a regulation that says, the board doesn't have to do the same thing every time, you certainly get accused of treating people differently if you decide that, this licensee who violated this rule today is gonna be, I'm going to request a suspension, whereas next year maybe I'll just ask for a civil fine. And I think we all want to be consistent in the application and enforcement of our rules. So deciding what the appropriate penalty may be for a certain type of violation is challenging, and I have to say that our enforcement rules are not very specific about providing guidance about what the types of violations or penalties should be. So that is something where we could see some improvement, is more specificity there. Clear rules and regulations. I think we all start with regulations that we think, okay, we've covered all the issues, these are going to be great. And then you start implementing them and you see problems. Oh, well, we didn't anticipate this happening over here, or this creative thing that a licensee is doing isn't really addressed in our regulations at all. So we are continuing to refine our regulations. We have about 15 current open regulation projects for changes. In our state, the board can consider regulations changes at any time, but the process to change is quite lengthy. 4 to 6 months to have a regulations change would be considered very fast. So we're constantly working on those and keeping everybody updated as to the current status of what the regulations are is challenging. Testing has also been challenging. We only have 2 testing labs in our state, which isn't very many. As I mentioned, 1 test per harvest batch, no matter the size, may or may not be sufficient, and 1 edible per production batch. Like I've seen a production batch that's 2,300 pieces. 2,300 pieces, yes, 2,300 pieces. And when you're just testing 1 piece, are you really understanding the situation in that edible, and are you adequately testing for homogeneity and that sort of thing? Also, in most industries that require some sort of testing, the federal government usually sets the methodologies for testing, and of course we don't have that in this situation. So there isn't really a standardization of testing methodologies, and we're seeing, one of our labs accusing the other lab of, inflating their numbers on potency, but we don't really know, are they inflating their numbers on potency, or do they just have a different methodology? So we're trying to work through those issues. Not being a scientist myself, I find it a little challenging. Keeping up, industry on the control board. This is an issue that's very interesting. It has pros and cons. I'm not in any way trying to say it's a bad thing, but it does have pros and cons. Pro of having industry on the board is that they bring a lot of knowledge about the industry that we don't necessarily have, and a perspective of the industry, which is very important to have in our processes. But the downside is that they can really push for kind of a business normalization, like we want to be treated like every other business, that really the climate for marijuana regulation really isn't there yet. I mean, we're illegal at the federal level, and in Alaska, 53% of the population voted yes, so 47% said no, we don't want this. So the climate for just being like any other business, we're just not there yet. So sometimes the industry members are kind of pushing the envelope a little bit faster than everyone's ready for. Keeping up with the industry, again, trying to stay abreast of all the innovations that are being made by licensees and by the industry can be challenging, and of course, the uncertainty at the federal level. Alaska-specific issues, again, as I mentioned, we didn't have an established medical dispensary system, which has had our whole rollout be much slower than it might otherwise have been. The distance between staff and licensees in our state has the potential to be very great. We have a very large state. And so getting to all of our licensees regularly is sometimes challenging. And then transportation, which is an issue that I believe is also shared by our neighboring state of Hawaii, that we have a lot of communities that are not on the road system. And so while most of those don't have commercial marijuana facilities, the few that do, the transportation of getting product to testing labs and to markets is challenging. And we have no control over that because air transportation and transportation by water are governed by the feds. So lessons learned and best practices. I know Kyle talked about this yesterday, the precautionary principle of, if we're unsure of what the impacts or effects are, don't go there yet. We're not ready yet. And starting with tighter regulations that can be loosened up later on. If you start very loosely, it's much, much harder to kind of tighten up if you learn that those looser regulations are problematic. Focusing on public health and safety, making those things the basis of your decisions, and of course not taking anything personally. If you haven't already, I'm sure at some point you're going to be accused of trying to shut down the industry by some decision that you make. So not taking it personally. And that's all I have. Thank you.
Okay, so our final presenter on this panel, and we're running a little bit behind, but we will try and save some time for questions at the end, and I think we have a break after this, so if there are questions we don't get to during the panel, you can catch the folks that you're interested in talking to outside of the room. Our final presenter is Joe Nikita. Joe is the Cannabis Management Officer for Los Angeles County and heads the county's Office of Cannabis Management. The office was responsible for coordinating the County Board of Supervisors' cannabis policies affecting approximately 1.1 million residents of unincorporated LA County, and works closely with LA County's 88 cities, other counties, and the state of California to promote uniformity and best practices for cannabis regulation. Joe previously worked as Senior Deputy County Counsel for Los Angeles County, representing the county's Planning Department, Planning Commission, Museums, and Art Commission. Please welcome Joe Nikita.
Yes, I had a much happier life with museums and arts commission before this, so I'm a little out of my element. I'm used to these very emotional public hearings, so if you guys might shout at me a little bit, maybe during the presentation, if you could cry in the first row every once in a while, Brandon Goldner from Portland, I think that would help me. I'm going to talk about what the state of California is doing from a local perspective. So you're going to get my opinion on this. Some of this is a little skewed, but it's my opinion. The state is doing a good job. The people working there are working really hard. I'm not implying that they are in any way deficient. They are doing a great job, but it is a difficult position that they are in to get things up and running by January 1, which is their deadline. How many people here are from California? Okay, I might trigger some PTSD as I go through this stuff, so just bear with me. Background. So the first time, and this is 1996, so I was a senior in high school, and this just blew by me. I had no idea this was happening. Prop 215, the Compassionate Use Act, first in the nation, essentially, I'm going to say legalized medical cannabis for, we do say cannabis in California, medical cannabis for qualified patients with a valid doctor's recommendation. Now, there's more to it than that, and there was some intervening laws between 1996 and the future, but you had to wait quite a long time after 1996 before you saw the next set of really significant regulations. You had to wait quite a bit before you got there. So now I'm 10 years out of law school. Again, this blew by me. This is the Medical Cannabis Regulation and Safety Act. This was adopted by the legislature. Actually, the legislature put into place a framework for medical cannabis in the state of California. So this wasn't a voter initiative. This was the legislature coming up with the rules, which doesn't always happen in the world of cannabis. It didn't last long because really months later you had Proposition 64, which was patterned off Amendment 64. This is the Adult Use of Marijuana Act. This was a voter initiative. This legalized non-medical or adult use cannabis use, possession, and cultivation for personal reasons within limits, and they're pretty common: 1 ounce of dry flower or 8 grams of concentrate. It also established a regulatory framework for adult use cannabis. So that's the commercial end of it, which is what I'll talk most about today: cultivation, manufacturing, distribution, retail, testing. They mandated in this proposition, in the will of the voters, is that licensing at the state level needed to start January 1 of 18. So we really just had our first set of state laws in place in 15-16 in a series of bills. Then months later, the voters say, no, we want you to do this by January 1 of 18. It's only 11 months, or I'm sorry, it's 13 months or so, which if you guys are in government, you know that is not a lot of time to do really anything at all. You might get your study done in 13 months, but building an entire regulatory program is a challenge. So there's more to it though, because the state started to develop regulations. In fact, they issued regulations in April of 17, but in June of 17, there was a budget trailer bill. Again, this is legislation. It's called the Medical and Adult Use Cannabis Regulation and Safety Act, or MALCRSA as we all call it lovingly. Again, this is legislation. It repealed MCRSA and added some of those medical provisions to AMA. So you have MCRSA plus AMA equals MALCRSA, which in the end of it all is one regulatory framework for medical and adult use cannabis in the state of California. So that's what we're dealing with now. So I'll talk about this in a second, but what happened to those draft regulations which were issued? They were withdrawn. So now we're in a state where we don't have regulations, and I'll talk more about that. So this is an overview of how the state is going to license cannabis at the state level. You have essentially 3 primary licensing authorities. There's more agencies involved in this, but these are the primary ones. You have the Department of Public Health, they will do manufacturing. You have the Bureau of Cannabis Control, which sits within the Department of Consumer Affairs. They will handle retailers, distributors, and lab testing. Originally, Public Health was handling lab testing, but it was sent to the Bureau, and I don't actually know why, but I'm sure there's a good reason. California Department of Food and Agriculture, they will handle cultivators, and they are primarily responsible for developing the track and trace program for the state. So the dual licensure. Now this sounds like this is pretty common among states that have legalized marijuana or cannabis. The state will issue a license, and in most cases the local also has to issue a license before a business operating in a local jurisdiction can operate legally. Under California state law, however, because there are a lot of cities in the state of California, there are a lot of counties in the state of California. Some of those counties, some of those cities are doing nothing. And that's basically, politics. But the state is worried. How are we going to deal with an applicant who says, I want a license if the locals are doing nothing? So they have developed a presumption. They can presume that a business is in compliance with local law if you basically show them anything. And now I'm being a little facetious, but if you work in government, you know that, let's say you want to license a restaurant in your local jurisdiction, they might need a CUP or at least a plot plan approval, something like that. They might need a health permit. They probably do need a health permit. They'll need something from building and safety. They'll need something from fire. There's no one permit that they get that says, okay, now you can go operate. They need to get all these permits. And so I don't know what the state expects to get, but I think a lot of jurisdictions in response to this are developing like a letter of, hey, this is okay, state, please issue this license. So it's something to work through, and maybe it'll be better than I think it will be, but that's something I want to note. So more about regulations. We had some regulations in place. They were only for medical, but everybody was like so excited about these hundreds of pages of regulations. They have been withdrawn because of Mount Cursa. And now we have one regulatory framework for adult use in medical. We are expecting emergency regulations from the state to issue 45 days or 15 days, somewhere in that range, before licensing is supposed to begin. I say 45 days because the state says we're going to get them out middle of November, but then I heard another rumor that they're not going to get out till December. I don't know what the answer is. Is there anyone here from the state who wants to answer that question? No one here from the state? That means I can say anything? Okay. All right, so these emergency regs will be, limited notice. They'll come out, and there'll be, I think, 5 days publication, and then later on there'll have to be, regular regulations passed. But for now, we'll deal with emergency regulations. But that means that basic information about how a business is supposed to operate is missing. So jurisdictions that are starting to license, and they are starting to license, and I'll tell you why in a second, locally, they may be coming up with regulations or no regulations for their local businesses that will require significant operational changes once the state issues their regulations. So again, more on state regulations because it really is an issue that we're dealing with locally. Because LA County is so big, we have 10 million people in the county. Many programs that are statewide programs are actually implemented locally through delegated authority or through contract by county officials, including in our cities. For example, our health department is the health officer for 85 of the 88 cities that we have in the county. Our ag commissioner does all of the agricultural work by contract with the state. But we're not sure yet, because we don't have the regulations, whether authority will be delegated down or whether there'll be contracting opportunities. So we don't really know what sort of the role will be of the state versus the counties and the cities in regulating cannabis, which, about a month and a half now from licensing, it makes me kind of nervous. Temporary licenses. So this is more wackiness, and I'll tell you why. So Proposition 64 did establish that mandate to have the state issue licenses in January 1. It was such a big task that the state had to come up with some way of achieving that mandate, and the interim solution is temporary licensing. So they are going to issue temporary licenses starting in January 1. This has created a race at the local level especially for cash-strapped community cities, municipalities, counties that want to make want to add to their budget with cannabis tax revenue, they are starting to create regulations really quickly and license businesses locally so they can be first in line for a temporary license at the state. It doesn't leave a lot of time for these jurisdictions to really think about what they need to be doing in terms of regulations, so we anticipate a lot of adjustment going forward. And this is really important to LA County because we do have 88 cities. Not all of them are moving to license, but at least a dozen are, which creates really some issues that I'll talk about in a second. Okay, testing. And I know this happened in Colorado. I understand for 14 months there was a moratorium on testing. The state regs that were issued for medical cannabis did have a 180-day moratorium on testing, so you actually didn't need to test any product that was sold to consumers through the license system. You just had to have a label that said, hey guys, this isn't tested. So we expect the same thing to happen because we really don't have a lot of licensed testing labs, and we are cognizant that requiring testing with not enough labs will create bottlenecks, will create issues and things of that nature. So in the meantime, you can expect more of these hard-hitting, local news programs that show, they go into the dispensary with a hidden camera, they buy the product, and then they test them, and they all test positive for pesticides, and then they call me, and then what's going on. So we expect more of that to happen. It sounds like, because there's dual licensure in many jurisdictions in many states that are legalizing cannabis, that there is the opportunity for a patchwork. That is really accentuated in California, and especially in LA County and some of the southern counties, because our cities are basically one metro area. So you drive from one side of the county to the other, you're going to pass through 40 cities without even knowing it, and a large unincorporated pocket. So locals can decide what businesses to allow. In fact, we're seeing a lot of locals that aren't just allowing cultivation, manufacturing, testing, distribution, and not allowing retail. So there's only about 4 or 5 jurisdictions that are going to allow retail right now. So it's going to put a lot of pressure on those jurisdictions in terms of having customers from other communities going there to purchase their cannabis. State law sets a default buffer of 600 feet from some sensitive uses, but the locals can eliminate those buffers, they can add buffers. This has the opportunity to create some conflicts among jurisdictions, because if one jurisdiction has a really low buffer and they're not buffering from their neighbors' uses, that could create impacts on that border street from one city to the other. We have seen some of that happen already in Northern California between counties and cities within the county. Taxing. So each city can decide to pass a local tax on cannabis sales, and they can do it in any number of ways. They just can't pass a sales tax. It needs to be a gross receipt tax or a cultivation tax. The state does have a 15% excise tax on retail, and they have a sort of a dollar amount per amount cultivated. So locals there's no limit to what locals can adopt. We've seen some locals adopting 5% tax rates. We've seen some locals adopting 17% tax rates. And we really don't know at the end of all this how that's going to affect the market in the county. More on patchwork. So there is a provision in state code that says a local jurisdiction can establish additional standards, requirements, and regulations. Now, it's pretty broad, and we like that. Locally, we like that because it lets us do whatever we want to do. But when you have a product that is really a statewide product that can be grown in Humboldt County and driven to some other manufacturer somewhere else and then sold in City of Los Angeles, these might actually create some real issues. And we're talking about potential supplemental warnings, supplemental packaging requirements, supplemental labeling requirements, which we have been asked to do by public health advocates. There could be local THC potency limits. There could be product-specific rules. For example, you can't sell a cannabis-infused beverage in some jurisdictions. You might have more stringent background checks in some areas than others. So there is some adjustment that will go on there. So how is this playing out in LA County? So here are some fun facts about LA County. We have 88 cities in a large unincorporated area within the county, 10.1 million people. Our top 3 population areas are listed there. City of LA is the largest. They have 3.9 million people. And I know Kat Packer is here from the City of LA. She's the head of their cannabis department. She probably has the hardest job in all of California to get her cannabis industry regulated in the city. Unincorporated area is the next largest community. We have 1.1 million people, but we're spread out all over the county. So we would be the 4th largest city in the state of California if we were a city, and our next largest city is Long Beach with 470,000, and all 3 jurisdictions are moving forward with licensing and regulating cannabis. A note about LA County, 50% of our unincorporated county population is actually contained in 2% of our land area, and I'll show you the map on the next slide. But we have some really, really dense urban pockets, and then we have coastal mountains, Malibu, Calabasas, where all the B-list celebrities live in the country. And then we have, and then A-list is Malibu. And then we have really this large area of high desert, low populated areas. We have suburban. We have a lot of different types of communities. So preparing a countywide program is really difficult for us in unincorporated county. And our budget is $30.058 billion. So sorry, Colorado, I think we beat you by $1 billion. But and I put that up there just to say that. So this is our map. So pink is unincorporated. You can see the challenge we have when we're trying to create a countywide program. I can't get my laser around to show you where the population centers are. But the 5th district up in the top is really sparsely populated. It's most of our land area. Then right by the 1 and right by the 2, that's South LA. It's East LA. East LA is actually unincorporated. So the Cheech and Chong, the original marijuana movie. That's unincorporated county. So we still have a lot of marijuana in East LA. Here are some not so fun facts. So until very recently, almost all cities and unincorporated areas banned commercial cannabis of all kinds. that includes LA City. They did have some limited immunity provisions in LA City that allowed some businesses to operate, but only about 180 or so. But there are some estimates that there are actually 1,700 unlicensed dispensaries in LA County as a whole. Most of them are in LA City by estimates, but we have about 60 to 120 in unincorporated areas, depending on the day. These fluctuate. Most of those are concentrated in our lower income communities and industrial areas, and about half of those are in East LA. And East LA is about, there's about 150,000 people living there. It's probably 2 square miles. So it seems really, really concentrated. We don't have any good estimates on how many unlicensed cultivation manufacturers. We visited a cultivator operating just outside of downtown, and he said all these warehouses are cannabis. So, we didn't go into all the warehouses, but I believe him. All this illegal cannabis activity has caused some real problems, and I mentioned those community meetings where people do cry and they do yell and they ask rhetorical questions that you can't answer, like, what about the kids? How do we transition from illegal to legal? It's really, really challenging. Do we reward unlicensed operators with licenses? We recently did an analysis of who might qualify, and these are the worst of the worst. They have minors working there. They have criminal activity. They are gang operated, some of them. So it's a real challenge to take the existing industry and move it into the licensed industry. If you start licensing businesses, how are they going to compete against so many unlicensed businesses? I'm not just talking storefronts. I'm talking about delivery services. You can open up Weed Maps, and it's covered in cars because there's delivery services all over the place. And if you live in an impacted community, for example, East LA, we've heard, why should we trust you, county? You can't even stop the illegal ones. How are you going to regulate the licensed ones? So it's something we're working through. Again, I don't have my laser pointer, but if you have really good eyes, how many dispensaries, this is East LA, how many dispensaries do you think are in this picture? Can anyone take a guess? We have 6. So we have Top Flight, McDab's, Happy Buds, East LA 23 right there in the little strip mall, and then across the street by one of our famous palm trees, we have 2 more there. And you can see there's no parking. It's just a mess. And some of this is just quality of life stuff: loitering, the smoke, the parking. Businesses that are adjacent. There's like a barber shop next door that's on the picture. They just get the smoke constantly in there. So this is what we're dealing with. I recently drove by this. It looks bombed out. It's been shut down, but it literally looks like someone blew up a bomb in one of these buildings, and then McDab's moved somewhere else, so they're still in business. Public engagement, we did have, I heard Nevada do 60 meetings. You did beat us. We had 10 town hall style meetings in communities, and then we had about 20 public workshops. They were, they were eye-opening. We asked for input on youth access and exposure, where businesses should locate, taxation, revenue, equity, economic development, and personal cultivation. We've learned some things. Most people are afraid of storefronts. They just really are leery about storefronts in their community. I'm not talking about industry. I'm talking about people that live in the communities. People have a lot of ideas about what should be buffered, and I have a list here: schools, daycares, parks, residences, places of worship, libraries, liquor stores, senior centers, senior housing, drug treatment facilities, group homes, affordable housing, and a whole bunch of other stuff that they've offered up as buffers. And they want them 2,500 feet to a mile from these buffers. So if you we have this GIS map that grays out the area. So if you just add a 300-foot residential buffer, the entire county map is wiped out, except for our 5th district, which is wide open up there. So the more you put buffers in, I heard Portland talk about this, I heard Seattle talk about this, the more you actually impact lower income communities because they are industrial adjacent, they are less likely to have parks and other amenities. Now, I have tried at community meetings to deliver that message. It is not well received. As someone, to tell somebody who has the potential for a business to open up across the street from their local park, to tell them, hey, don't worry, this is equitable, that doesn't come across very well. So I've been pushed out. Okay.
2 minutes left.
Oh, it's good because I have 2 minutes left in my presentation. Okay. So a couple things we've learned. A yes vote on Prop 64 is far different than saying, okay, I'm okay with commercial cannabis in our neighborhoods. People want a ban, and they think the ban will make the problems go away. We have a ban. We have lots of illegal activity going on. We do have gang members and criminals operating these businesses. Not everybody, but there is a lot of that, which affects the perception of these businesses. Communities that have dispensaries want to see tax revenue come back to the communities. And then in terms of timeline, we're looking to license somewhere in mid-2018. We're a little bit behind our neighbor, LA City. Summit cities have already started issuing licenses, like I mentioned. So that's pretty much it. We have a lot of resources on our website. We've done a lot of outreach. We have reports up there. We've had an advisory cannabis working group with recommendations. So if you're interested, go to our website, see what we have. We're happy to talk to you if you're in California or anywhere about public engagement and lessons we have learned. So thank you.
So I think, unfortunately, we're about out of time. We're supposed to wrap up at 10. So I think the 4 of us can hang out up here, and you guys can take your break. And I think we'd be happy to answer any questions you guys have. I apologize for eating up all the time, but Dan, that'll teach you to let me be in charge of anything. So thank you guys very much. I appreciate it.